All right, good morning, everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, I will let you know if I've determined probable cause from the police reports I read this morning, and then we will talk about release conditions. Today is not your trial date. It's not an adversarial hearing, and so I encourage you to speak with your attorneys before speaking on the record, because everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office, you need to know that in the courtroom with me, I have Mr. Brian Reedy, and over at the main jail, there is another attorney also from the Public Defender's Office. For those of you at the other facilities, these attorneys are available to you by phone. For those of you represented by private attorney, those attorneys will come to the courtroom and address your case from here. If your attorney's not here when I call your name and you know that you or your family have in fact retained private counsel, you can let me know. If you let me know the name or if you have the phone number, I will try to make a phone call. However, please don't tell us that you have private counsel unless, as I said before, you or your family have retained that person for this arrest. Because an attorney represented you in the past, or because they are probably representing you on a pending matter, does not automatically mean that they're representing you on this new arrest. And so you need to keep that in mind. And some of you, I've been told before that some persons say that they have attorney on permanent retainer. Well, unless that's true, please don't tell me that, because when I call these attorneys, they are going to tell me they're not representing you. Also in the courtroom with me, I have the attorneys from the state attorney's office. I have Mr. Eric Linder, and we also have representatives from confinement status, pretrial supervision, the clerk of courts, and all these persons are here to help facilitate the morning's process. They can provide additional information if needed. For some of you, those of you charged with misdemeanors or municipal ordinance violations, you may be able to resolve your case at first appearance, but that's also dependent on what's going on with you personally. So just bear that in mind. Those of you charged with felonies, or those of you who are facing violation of felony probation, or even if it's a misdemeanor probation, if that judge signed that warrant and said no bond, there is nothing that I can do about that today. You will have to go see that division judge to deal with that issue, okay? After today, if your case has not yet already been assigned to a division judge, it will be. And then moving forward, any pretrial motions, or if you end up going to trial, those matters will be heard by that division judge. I may or may not see some of you within 30 days if there are 30-day motions, or if there are a second look at your bond status later on. But for the most part, the bulk of whatever is going on with your case will be heard by your division judge. All right. Mr. Reedy, is there anyone that the jail has asked to call out of turn?
Yes, Your Honor. In fact, we have 6.
Oh, okay.
And I'll give them to you in chronological order.
All right.
On page 12, Mr. Jones.
Okay.
On page 15, Mr. Baker.
Okay.
On page 20, Mr. Kelly. On page 21, Mr. Valdez. On page 22, Mr. Beckford. And on page 24, the other Mr. Beckford.
And just before we begin, just so we know, for those of you, if you're a private attorney or if you're family members who signed in, depending on where your client is on the docket, they may not be in the room because the jail does not bring everyone in at the same time. So if you, like I see Mr. Salantri, did you ask them to check to see if your client was already in the room? All right, so, Mr. Romero, it's okay, I'll do it. Mr. Romero,
Yes, Judge.
on page 27, if you let me know, if or when Gerald Zafuto, he's on page 27.
He has private counsel?
Yes,
Okay.
so let me,
They're gonna go and get him now.
all
Thank you,
right,
Judge.
all right. Okay, so, Reginald Jones. All right, Mr. Jones is before the court this morning. Charge 1 is aggravated battery with a deadly weapon. Number 2 is resisting officer without violence. I find probable cause for these charges, and I'll hear from the attorneys at this time.
Mr. Romero wants to go first. I'm just looking up some information.
Okay.
Judge, my understanding, Mr. Jones does have prior contact with the criminal justice system, but I believe it was in 2014 now. He's 31 years old, been residing in our community his whole entire life. He works at a place called SMG. It's a sand plant. He's been in there employed for about 5 months now, making only $10 an hour. Now, I did advise him because of the domestic situation, there's going to be a no contact order entered. He'll be living separate and apart from the alleged victim. He'll go and reside with his mother, who lives here locally in Fort Lauderdale. Now, my understanding is his mother is retired. She's on a fixed income, collects Social Security. That's who's going to be helping him post his monetary bond. Judge, I'm going to be requesting a $5,000 bond on his behalf. That's still probably going to be really tough for his family. But he said maybe if they can all pull their resources together, that going through a bondsman, maybe that's something they can afford. And also, we're going to be asking for the court to enter a photo order so we can photograph the injuries that Mr. Jones sustained.
Okay.
Your Honor, based on the level of violence in this case, and also his priors, which I will advise the court of, I'm going to be requesting a $50,000 bond, pretrial release with a GPS monitor. Mr. Jones was arrested in 2014 for battery against the same alleged victim. That was dropped. 2013, grand theft, violation of probation, sentenced to 58.5 months in Florida State Prison. 2013, battery against the same alleged victim. That was dropped. 2012, arrested for aggravated battery against a pregnant victim and battery against the same alleged victim. Those charges were dropped. 2011, burglary of a structure, criminal mischief, violation of probation, 58.5 months in Florida State Prison. 2011, uttering a forged instrument with a VOP, same sentence. 2009, strong arm robbery with a violation of probation, theft in 08. Nothing further, Judge.
All right, with information that there has been prior violence against this same alleged victim, and then this probable cause affidavit that is before the court today, the allegations are that Williams told Jones that they could no longer be together. Williams then reached down for an article of clothing and felt something hit her back. She then saw the blade of a knife coming towards her, and she dropped to the floor. After she fell to the floor, Jones stabbed her 2 more times with a knife before breaking its blade in Williams's side. He then went to the kitchen, grabbed a second knife. She saw him coming, attempted to close the door to her room, but he was able to gain entry despite her efforts to resist him. And once Jones entered the room, Jones stabbed Williams with a second knife several more times. And after stabbing Williams, Jones fled the scene, and he was later pursued by law enforcement. And so based on these allegations, I find that these allegations are quite alarming. As to the aggravated battery, I am going to impose a $100,000 bond. And if he posts his bond, he'll be on level 2 pretrial supervision. There will be no victim contact, and no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir? Does Mr. Jones understand the no contact order?
He does, Judge.
All right?
He did.
And there will be, Mr. Jones, I am not done. There will be a 500 feet stay away order at this time, so you cannot be within 500 feet of the alleged victim. All right, I just have a few more that I have to call out of turn for the jail, okay? Tony Baker,
Mr. Baker's here, main judge approaching. Come on up, Mr. Baker.
all right, Mr. Baker is before the court this morning on one charge of false ID given to law enforcement officer, and I find probable cause.
Judge and speaking, Mr. Baker, he wishes to resolve this matter today.
All right, based on these allegations this morning, I'm not inclined to take a plea offer at this time. This is, it looks like Mr. Baker's second time at this particular location. Previously, he attempted to gain access to this particular school to pick up a child that wasn't his. And then, on this incident, he was seen again at that location. So he has a $100 bond, which I am going to increase to $500, and no return to that location.
And Judge, Mr. Baker advised me that he can't afford the bond, 500 or 100. He's asking if the court would consider releasing him today.
No, I'm denying that at this time. All right, on page 20, Camry Kelly.
Please approach the judge.
Mr. Kelly is before the court this morning on one charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause.
Judge, from what I see, the bond here is indicated $100,000. That's something Mr. Kelly cannot afford. My understanding, he's been here his whole life. He's 25 years old. He's a mechanic, self-employed as a mechanic / painter. He can make anywhere from about $700 to $1,000 a month. He lives in Lauderhill. He's been residing at the same premises now for the past 2 years with his girlfriend. My understanding, his girlfriend is employed. She works at Pollo Tropical. My understanding, Judge, and speaking, Mr. Kelly, this incident, I believe, happened about 2 months ago. My understanding is that the alleged victim reached out to Mr. Kelly, advised him he did not want to pursue these charges. My understanding he's probably going to go to the state attorney's office, fill out a waiver of prosecution. So I'm asking the judge if the court, considering Mr. Kelly's strong family ties, would consider a reduction to $10,000 on count one, Judge.
And his mother is present, Your Honor.
Okay,
Criminal history, 2019, resisting without violence in July. 2015, possession of PVP, a year and a day state prison. 2013, 3 counts of sale delivery of cocaine within 1,000 feet of a place of worship. He violated probation, was sentenced to a year and a day state prison.
and, Mr. Linder, you have any indication about any waiver of prosecution? Is there any notes?
It's on an arrest warrant, Your Honor, so I'm not aware of that.
Okay, all right. I am taking note that this alleged incident occurred in September. I'm assuming that if someone wanted to file a waiver of prosecution, it's almost 2 months, that would have been done. Mr. Kelly's mother is here. Did you want to address, did you want to say something? If you're going to speak, I'm going to ask you to come up to the podium. You don't have to. I'm just saying you're here. Sometimes people are here, they want to talk, so. Oh, okay. Okay.
Good morning. I just wanted to just pretty much let you know, Your Honor, and the court know that my son is not a violent person. And this whole thing, I think, is a misunderstanding. And pretty much to try to get him an affordable bond because he's a big help to me. I have guardianship of my grandson, and he helps me out as far as picking up after care and, you know, different other little things that he can help me out with. And even at $10,000, that's a little steep, but, you know, if
The allegations that I have before me, and that's what I used to make a determination as a probable cause, is that he held a gun to someone who was sitting in their vehicle. And like I said before, if that person is going to file a waiver, it hasn't been done yet, so that's not something that I can take into consideration because I don't know that that's truly going to happen. The judge who signed the warrant, because this was a warrant, and the judge did sign the warrant with $100,000 bond, is, Mr. Romero, I don't remember what you said, is Mr. Kelly working?
Yes, Judge, he's self-employed, mechanic slash painter.
And Mr. Linder, he has a 2019 other arrest. Is he out on bond, or has that case
No,
been
that,
resolved?
I'm sorry, that was pled out in July, Judge.
That was pled out in July?
Yes, ma'am.
And what was the charge again?
Resisting without violence.
And aside from that, the next most recent thing was 2013?
One moment, Judge. 2015 possession of PVP, year and a day state prison.
So based on the allegations at this time, I will reduce the bond to $50,000 and no victim contact.
Or just ask for an additional condition
No
of,
weapons or
thank
firearms.
you, Judge.
Right, McGrowins Valdez.
Mr. Valdez, come on up, please.
All right, Mr. Valdez, you're before the court this morning. Charge 1, battery on an officer or firefighter. Number 2, resisting officer with violence. And number 3, attempt to escape. And I find probable cause for these charges. State.
One moment, Judge. Your Honor, I'm going to be asking for a $10,000 bond on count 1, a $1,000 bond on count 2, $50,000 bond on count 3. Should Mr. Valdez post these bonds, pretrial release with a GPS monitor level 1. I'm greatly concerned based on the allegations of his attempted escape while in custody at the jail, that he attacked an officer in the jail as a means to succeed with this attempted escape. I would also note, Your Honor, when this occurred, Mr. Valdez was in the jail because he had a no-bond hold from another county for violating an injunction order of protection.
Judge, 61,000, there's no way Mr. Valdez can afford it, nor his family. My understanding, he's been living in our community for well over 20 plus years. He's 34 years old. He lives in Pompano Beach with his girlfriend. They've been residing at the same place. They rent, they do not own. Their monthly rent is approximately $1,200 a month. Now, he is employed. He works for a company called Hand and Stone. He's a massage therapist. He's been working there for the past 3 years, making approximately $600 per week.
3 children.
Judge, he's with all the bills, from what he advised me, they just paid the rent, taking care of their children. There's no way they can afford anything close to what the state is asking for, Judge. That's why we're gonna be requesting on count one, a $1,000 bond, on count two, a $2,000 bond, and on count three, a $500 bond on Mr. Valdez's behalf.
All right. Here, the allegations are quite alarming. He's in custody. He tried to escape, and the officer tried to stop him. He pulled the officer in an elevator, beat on the officer, was able to overcome the officer, who was trying to pepper spray him to stop him with this level of violence, and taking into consideration the prior history at this time. I am going to, on charge one, enter a $50,000 bond. He'll have a $1,000 bond on two and a $50,000 bond on three. And if he is able to post his bond, he'll be on a level one pretrial supervision. All right. Fernando Beckford.
Your Honor,
I'm sorry, that's okay.
and Your Honor.
Yes.
If I could be heard before the court makes a finding.
Okay,
Mr. Beckford, Fernando is approaching, Judge.
okay. All right, the state wishes to,
Your Honor, I'm going to ask that the court, pursuant to the rules of criminal procedure, defer making a finding of probable cause until tomorrow morning. Your Honor, I've reached out to the detective. I've not heard back from him yet, conceding and noting that the report does not mention the age of the child.
okay,
And noting he was arrested according to the probable cause, the booking, November 12th at approximately 3:45 in the afternoon. First appearance hearing tomorrow morning would be within the 48 hours governed by the rules.
all right. I'll grant the state the 24 hours based on the
That's
nature of the
over
charges.
objection.
Okay. All right, Marquise Beckford.
He's approaching, Judge. Huh? How you doing, Your Honor?
Mr. Beckford, good morning, I'm well. You are before the court, Mr. Beckford, on one charge. Charge one is resisting officer without violence. 2 and 3 are felony violation of probations. Those have no bond holds. And you will see Judge Garcia Wood tomorrow at 8:30 a.m. on the violations. I find probable cause, and you have a $100 bond on one, okay?
So I couldn't much talk to you?
All right, do we have Mr. Zafudo as yet?
He's here, Judge.
All right.
Private attorney is here.
All right, so Mr. Zafudo is a reset from yesterday, and Mr. Salantri, have you had an opportunity to speak with the state? Is there any agreement at this point? Okay,
Your Honor, I'm going to be seeking no bond holds on the two punishable by life.
okay. So let me just repeat that Mr. Zafudo is before the court this morning on charge one, burglar with assault or battery. Number two, criminal mischief, over $1,000. Number three, burglar for dwelling or structure causing damage, over $1,000. 4 and 5 are burglary, occupied structure unarmed. And number 6 is grand theft. And I find probable cause for these charges. All
Your
right,
Honor,
yes.
on counts or charge numbers 1 and 3, they're both punishable by life offenses. The state is going to be seeking, for first appearance purposes only, a finding of proof evident or presumption great, and that Mr. Zafudo be held no bond. Your Honor, should the court find proof evident or presumption great, the state would further ask that the court exercise discretion in not setting a bond at this time and allow Mr. Zafudo to have an Arthur hearing in front of his assigned judge. The reasons for that being, Your Honor, first I would note the burglary with assault or battery, the state has already filed designation of career criminal court. That case, I believe, is going to be going before Judge Bober. Your Honor, as mentioned in
Judge Murphy, I believe.
well, it was assigned to Judge Murphy, but now that we've, and the burglary with the damage over 1,000, I believe, is staying there. We filed the designation for career criminal court on the Berg bat, so that's going to be transferred to Judge Bober. As mentioned in the report, Your Honor, Mr. Zafuto not only has an extremely lengthy criminal history, but it also involves burglaries.
Okay.
Morning, Edward Solantri, on behalf of Mr. Safuto. Thank you for contacting my office and also resetting it for today. I did file a notice of appearance on one of the case numbers, which is the 299 case number. That was filed several months ago. I was in contact with the state, several prosecutors at the time, learned there was a second case, which I have not been retained on. As for purposes of today, I will stand in and represent him on the 5390 case number. But I have not filed a notice of appearance, and I'm not in a position to do so. I was only partially retained on the other case. We were in conversation, myself and the state, regarding a surrender and perhaps an agreement on an agreed bond on both cases. However, Mr. Safuto at the time, his source of financing dried up, and we're not able to proceed on the second case, and we were in the process of trying to get that done when he was arrested in this case. I'd like to point out that there are two separate cases. They're all burglaries. There's only one count that's no bond, and that is a burglary of PBL, and in the 299 case. Also, I'd like to point out that the 5390 count one also is a PBL, and that bond is set at $10,000. I would ask that the burglary with the charge burglary of assault with assault also be set at $10,000. There is the battery, if you will, or the assault, the alleged battery or assault was, if it occurred, was in process of fleeing, and he was attacked by the victim in that case. After he departed, again, the allegations, assuming that it was even him, the business at the time. So I think the assault / battery is very, very iffy at best. There's no presumption great at all in this case, and we would request an evidentiary hearing if that was, and would object to any finding of that at this time. Mr. Safuto, these allegations are all a couple of years ago, or a year and a half ago. He was suffering from a very bad involuntary drug problem at the time. They're all burglaries. His priors are all burglaries. There's no crimes of violence. I understand the one charge with an assault, but that was while he was fleeing. Short of that, there's no violence, there's no weapons. He's 50 years old, or almost 50, 49 years old. He was about to attain employment in his field as carpet installer. He is not a flight risk. He was around town. He did go to a residential treatment program for a period of time in Colorado. I do not have the records at this point. This is before the warrants were issued. He came back to town voluntarily. I can assure the court, as an officer of the court, that he was very motivated to surrender and address all these charges. He just didn't get around to it, unfortunately.
I know, Mr. Solantri, I know you weren't here yesterday, but one of the things I did make an inquiry, just in general, I was noting that this was from last September, over a year ago. And one of the responses that your client gave on the record was that he was on the lam. That was how he responded as to why this is just now before the court.
Well, he was also in treatment, in inpatient treatment program for an extended period of
Well,
time.
it's always curious, like, if that's what you're doing, most people, that would be the first thing that they would say, Judge, but that's not what he said first. He said, I've been on the lam. All right. Taking all of this into consideration, at this time, I am going to, on charges 1 and 3, make that preliminary finding of proof evident presumption great. This is without prejudice for Mr. Zafuto to have an author hearing before his division judge. And so until such time, on charges 1 and 3, he will be held no bond. It's
both.
two, it's both.
Just
Oh,
relating to Mr.
wait, I
Solange.
did have a question.
Yes.
I did have a question. On the case that you're already, a counsel of record, did he already post bonds on
No,
those?
no, here's,
He
if,
never appeared for a first
now,
appearance?
if I may, Your Honor.
Okay.
What's going on, and the reason, if you look in the docket for the case Mr. Solange is representing him on, it shows an arrest warrant number.
Okay.
What happened was, they issued the arrest warrant, they didn't make the arrest, they submitted all the paperwork to my office.
Okay.
My office made a filing decision, filed a not in custody report, and the ensuing case number is the case number that Mr. Solange is referring to. When they arrested him, they booked him on the arrest warrant, not the not in custody capia. So that will be corrected at a later date.
So
Okay.
it is 2991.
It's that case, yes.
Okay, and it probably was an error somehow, that I
just-
was even aware that there was a warrant, Judge, otherwise we wouldn't even have these discussions.
That's okay.
Just frankly,
Yeah.
the other one never showed up, I only found out through speaking to the state
Yeah,
attorney's office.
yeah, it'll just have to get taken care of to make sure that a second case number isn't issued upon the arrest on the arrest warrant number, that's all.
All right, and then on 4 and 5, then I'll impose $5,000 bonds on each of those, and then I'll leave the other standard bonds in place.
Thank you, Judge.
Okay?
Thank you.
Okay, Judge.
All right. All right, Mr. Spanish interpreter,
Thank you,
who needs, you're welcome, Mr. Salancho. Who needs the Spanish interpreter?
On page 10, Mr. Gonzalo Santamarina. Señor Gonzalo Santamarina. Judge, I've been advised his family hired private counsel, Mr. Jorge Alonso, and he's waiting for Your Honor's phone call, and I can give you his number.
All right, what's the number?
786-205-8104. And there is a second individual
and-
that's gonna be
What's his attorney's name?
Jorge Alonso, Alonso.
All right.
Find out when she mentions it to, when the judge mentions it to his attorney.
Good morning, is this Mr. Alonso?
It is.
This is Judge Jackie Powell, I'm calling from First Appearance Court.
Es la jueza Jackie Powell llamando al señor Jorge Alonso desde el Tribunal de Control.
I just need to let you know, one, that we're on speakerphone in open court.
Primero que nada, tengo que hacerles saber primero que estamos en altavoz en el tribunal.
Two, everything is a little bit delayed because we do have a Spanish interpreter.
En segundo lugar, todos hay un retraso, un rezago porque hay un intérprete al español.
Understood.
All right,
Entendido.
I have your client Gonzalo Santa Marina Martinez.
Tengo a su cliente Gonzalo Santamaría Martínez.
Yes.
Mr.
Judge,
Mr.
can you
Martinez,
advise me of the case number, please?
it's
¿Me
not a,
podría decir el número de expediente, por favor?
there is no case number, it's a first appearance issue, so
No hay
there's,
número de expediente, es la primera comparecencia.
the incident date is November 11th.
La
So,
fecha del incidente es 11 de noviembre,
so I don't have the case number at this time.
así que no tengo el número de caso en este momento.
All right. He is, charge 1 is burglary with assault or battery.
El primer cargo es hurto, incluido lesiones o agresión.
Number 2 is touch or strike battery, domestic.
El segundo es lesiones mediante toque o golpe en grado de violencia doméstica.
And number 3 is arrest victim or witness in a capital life felony case.
El tercero es acosar a un testigo como parte de un caso que podría dar como resultado la pena de cadena perpetua.
I have reviewed the probable cause affidavit,
Ya he visto el affidavit sobre indicios probables de delito
and I find probable cause for these
y
charges.
considero que existen indicios probables para estos cargos.
I understand.
All right.
Entiendo.
Charge number 1, just to be clear, is a
Para
first
ser
degree
claros,
felony.
el primer cargo es una felonía de primer grado,
Punishable by life?
penable con vida.
Yes, sir.
Sí, señor.
I understand.
And Your Honor.
Entiendo.
All right, I'll hear from the state at this time.
Voy a escuchar a la fiscalía en este momento.
And Your Honor, 3 is also a punishable by life offense based on the underlying offense.
Su señoría, la número 3 también es penable con cadena perpetua, dado el delito subyacente.
That's correct. Ms. Alonso, did you hear that?
Así es, señora Alonso.
Yes,
¿Escuchó
ma'am,
eso?
I
Sí,
did.
señora.
Okay, sir.
Your Honor, based on, well, I am going to be seeking a no bond hold on counts 1 and 3.
Su señoría, yo voy a solicitar que sea detenido sin fianza para los primeros, el primero y segundo, el tercer cargo,
Upon a finding of proof evident or presumption great,
si se halla que existe presunción evidente con presunción alta con prueba evidente,
with the understanding that any such finding is without prejudice and only applicable to the first appearance hearing.
en el entendido de que cualquier hallazgo de ese tipo es sin perjuicio de que sea modificado en el futuro y solo aplica para la primera comparecencia.
I would be basing this on the statement the victim gave to law enforcement
Y
contained in
esto
the affidavit.
estaría basado en la declaración que le dio la víctima a la policía
And the physical injuries suffered by the victim that corroborate her version of events.
en el affidavit y también las lesiones físicas sufridas por la víctima que corroboran su versión de los eventos.
Nothing further, Judge.
Nada más, su señoría.
Judge, at this point, I understand that, according to Florida law, my client does not qualify for bond because of the charges.
Su señoría, en este momento yo entiendo que con base en el derecho del Estado de Florida, mi cliente no es elegible para fianza debido al tipo de cargos.
And I appreciate the state saying that this is only for the purposes of this hearing and may change once the case is filed.
Y agradezco por parte, agradezco la declaración por parte de la Fiscalía de que esta detención sin fianza aplica únicamente para la primera comparecencia y puede ser litigada más adelante en una audiencia Arthur.
Okay. At this point, not having seen the actual arrest affidavit,
En este momento, dado el hecho de que no he visto todavía el affidavit del arresto,
to your honor, to decide whether proof is evident or presumption is great. I understand that you found probable cause, and I'll leave it up to you whether to grant the bond or not.
dejo a su discreción, señora juez, el hallar o no que existe prueba evidente con alta presunción y si impone fianza o no, si desea otorgar fianza o no.
All right, based on the allegations that I've reviewed,
Bien, con base en las acusaciones que yo he visto
and noting that the probable cause affidavit states that the incident occurred because Mr. Martinez found out that the alleged victim was seeking a restraining order.
y dado el hecho de que el incidente ocurrió porque el señor Martínez se percató de que la víctima estaba intentando obtener una orden de protección.
And that he advised her that if she called police or attempted to get another restraining order, he would kill her.
Y que le dijo que si ella llamaba a la policía o intentaba obtener otra orden de restricción, él la iba a matar.
There's also report that he has made her beg for her life in the past.
También se informa que en el pasado ha habido incidentes en los cuales él la ha obligado a suplicar por su vida.
And she did suffer injury, a 2-inch contusion
Y sufrió una contusión de 2 pulgadas
on her left upper arm
en su brazo izquierdo superior
and a 1-inch contusion on her rib
y
cage.
una contusión de 1 pulgada en sus costillas.
And so based on these allegations,
Con base en estas acusaciones,
at this time,
en este momento,
this court makes a preliminary finding of proof evident presumption great.
voy a hacer de manera preliminar el hallazgo de que existe prueba evidente con alta presunción
This is as to charges 1 and 3.
para los primeros y el primer y tercer cargo.
And Mr. Martinez will be held no bond.
Y el señor Martínez permanecerá detenido sin fianza.
And this is without prejudice for him to have have an author hearing before his division judge.
sin perjuicio de que se realice más adelante una audiencia Arthur ante el juez de su división.
As to charge number 2,
Con respecto al segundo cargo,
I will impose a $5,000 bond,
voy a imponer una fianza de $5,000
and at this time,
y en este momento
I'm ordering a no victim contact.
voy a ordenar que no mantenga contacto con la víctima.
No victim contact means no phone calls,
Y no tener contacto con la víctima significa que no puede realizar llamadas telefónicas,
no text messages,
mensajes de texto,
no social media contact,
contacto por redes sociales
no third party contact.
o contacto mediante terceros.
And there will be a 500 feet stay away order as
Y
well.
habrá un interdicto de protección mediante el cual se le prohíbe acercarse a una distancia menor a 500 pies de la víctima.
Okay? All right,
Thank
folks.
you, Your Honor.
Y
You're
gracias, su
welcome.
señoría.
All right.
We'll be filing our notice of appearance later today.
Más adelante voy a presentar mi notificación de representación.
All right. Thank you.
Could I just have the name of the ASA in court today, please?
¿Permite el nombre de la ASA?
Eric Linder.
Eric Linder.
Eric Linder.
Yes.
Thank you, Judge.
You're-
You have a good day.
You too, sir. Take care.
Gracias, señora juez. Buen día. Igualmente.
All right. Who else needed the Spanish interpreter?
On page 15, Judge, his name is Mr. Raul Oliva Santos.
And is there someone else?
That is all.
That's
correct.
it? Okay. Oh, Raul Oliva Santos. You're before the court today for one charge of trespassing on occupied structure or conveyance.
Raúl Oliva Santos, usted está ante este tribunal hoy acusado de entrar de manera ilegal en una estructura o transporte desocupado.
All right, I find probable cause.
Considero que existen indicios probables.
Judge, this is Mr. Oliva Santos. He wishes to resolve the matter, sir.
Señora juez, he hablado con el señor Oliva Santos, él desea resolver el caso.
Does the state have an offer for Mr.
¿La fiscalía tiene una
Santos?
oferta para el señor Santos?
One moment, Judge.
Momento, su señoría.
Your Honor, the state's offered be adjudication 3 days in county jail.
Su señoría, la oferta de la fiscalía sería una condena y 3 días en la cárcel del condado.
This is Mr. Oliva Santos's fifth trespass in the past year and a half.
Esta es la quinta vez que es acusado de entrar ilegalmente en una propiedad del señor Santos.
And Judge, Mr. Oliva wishes to accept the state's offer.
Señora juez, el señor Oliva desea aceptar la oferta de la fiscalía.
All right, Mr. Santos, please raise your right hand.
Bien, señor Santos, levante su mano derecha.
Do you swear or affirm to tell the truth?
¿Jura o firma solemnemente decir la verdad? Yes.
Okay, you can put your hand down.
Puede bajar la mano.
Mr. Santos, is anyone forcing you to resolve your case?
Señor Santos, ¿alguna persona le está obligando a resolver su caso? No.
Are you under the influence of drugs or alcohol?
¿Se encuentra bajo la influencia de drogas o alcohol? No.
Do you need any more time to speak with your attorney?
¿Necesita más tiempo para hablar con su abogado?
Your, your attorney is the gentleman standing next to you.
Su abogado es el caballero que está a su lado.
Do you need any more time to speak with him?
¿Necesita más tiempo para hablar con él?
No.
No.
All right. You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Entiende que usted tiene derecho a ir a juicio, sin embargo, al presentar este coloquio hoy, usted está renunciando a ese derecho. Yes.
Have you ever been treated for mental or emotional illness?
¿Alguna vez ha sido tratado para una enfermedad mental o física? No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Entiende, señor, que si usted no fuera ciudadano de los Estados Unidos, el aceptar una declaratoria de este tipo hoy podría someterlo a ser deportado. Yes.
All right. What plea do you wish to enter at this time? Guilty or no contest?
Bien, ¿cómo se declara en este momento? ¿Culpable o no me opongo?
No contest.
No contest.
All right. I accept your no contest plea.
Bien, acepto su declaratoria de no oponerse al cargo.
I find that it's freely and voluntarily given,
Considero que se ha dado de manera libre y voluntaria.
and your sentence is adjudication,
Y se le impone una condena,
3 days in the Broward County Jail,
3 días en la cárcel del condado de Broward.
credit for any time served.
Se le acreditará cualquier tiempo ya descontado.
And I'll also give you 6 months to pay your court
Y
costs.
le voy a dar 6 meses para pagar sus costas judiciales.
Okay?
¿Está bien?
All right. And no one else needed the Spanish interpreter, correct?
At this time here at Maine, no, Judge.
All right, thank you. All right, again, if, depending on where your client is on the docket, they may not be in the room. And so, Mr. Romero, if you can tell me if, Luis Garcia, who's on page 20 of the docket, is he there?
Luis Garcia, no, Judge.
All right, so if you'll let us know when Mr. Garcia is in the room,
Luis Garcia.
he has private counsel,
Thank you, Your Honor.
okay?
No problem.
All right, on page 11, Ward Rangan.
Mr. Rangan, come on up, please. He's approaching, Judge.
All right, Mr. Rangan, someone has signed in for Mr. Rangan, not an attorney, but Mr. Rangan is before the court this morning for one charge of aggravated battery causing bodily harm. It's domestic violence, it's a domestic violence charge, and I find probable cause. I'll hear from the parties. Good morning, ma'am. You don't have to. Do you wish to address the court? And are you the alleged victim in this matter? And so, ma'am, I know that your interests are represented by the state attorney's office, but you don't have private counsel here, and I cannot give you any advice except to tell you that the same thing that I said this morning as to all the defendants, everything that you say in this courtroom is being recorded, and also at a later time could be used against you. So, knowing that, do you still wish to speak on the record? All right, and so if you are going to speak on the record, I am going to put you under oath. So I'm going to ask you to raise your right hand. Do you swear or affirm to tell the truth? Yes, I do. All right, you can put your hand down, and I need you to step over a little bit so we can hear you through the microphone. And I'm going to ask you to state your name for the record, please.
Janaína Rangan.
Okay, and what is it that you wish to say, Ms. Rangan?
My husband, he's a very nice man. He's a hardworking, lovely husband. I miss him a lot already. I know this was all misunderstood, and it was an accident, and I do not want to be away from my husband. I want him back. He supports me financially, and he is the one that paid the bills. We are married for a year and 1 month. We have a beautiful ceremony. We never had this kind of argument. It was totally an accident. And we planned our honeymoon. Our honeymoon is going to be almost by my birthday. So we'll be celebrating the honeymoon, the anniversary, and my birthday. And I don't want those things to be taken away from us.
And I see that you have your arm bandaged. Is this bandaged as a result of the injury that's reported in the probable cause affidavit?
I didn't read the report.
Well, okay. Is the
But
injury from this
yes.
incident?
Yes.
Okay. All right, State? Thank
Your
you,
Hon-
ma'am. Is there something else you wanted to say?
If I just want an affordable bond because we don't make that much money, if it's possible.
Are you working?
just a part-time,
And how much money do you make?
like 400 a week.
Okay. All right. At this time.
Your Honor, Mr. Rangan has no history. That being said, I'm going to be requesting a $3,500 bond and no victim contact. The allegation is that he stabbed the victim in the hand. As Your Honor noted out, she is in court today with her hand bandaged, so it does appear, based on the allegations, that he caused injury that required some level of care and treatment.
All right, Mr. Romero.
Judge, as you heard from the state, Mr. Rangan has no prior contact with the criminal justice system. Their bond recommendation at $3,500, that's reasonable considering the circumstances. What I'm going to be asking is based on the alleged victim's testimony at this time. She wants contact with her husband. She said it was an accident, misunderstanding. So, Judge, at this time, I'm going to be asking for the court not to impose a no contact order.
All right. I'm finding probable cause. I am going to impose the $3,500 bond. I am also going to impose a no victim contact until further order of the court. And that means no phone calls, no text messages, no social media, no third-party contact until that order is lifted by a judge. Okay? So $3,500, no victim contact.
Judge, can Mr. Rangan go back one time with law enforcement to retrieve his property?
One time with law enforcement, yes. All right, on page 8,
Oh, Judge, there's a gentleman that just arrived that had private counsel. Come on up. What's your last name, sir? Mr. Garcia.
okay?
Your private attorney's there.
Morning, Judge.
Good morning again, Mr. McGill. And Mr. Garcia is before the court. He has charge 1, possession with intent to sell, manufacture, or deliver THC. Number 2 is possession of drug paraphernalia. And number 3 is the violation of felony probation,
Yes, Judge.
which he has a no bond hold for Judge Yuson.
Yes, Your Honor.
And my notes indicate that he'll see Judge Yuson tomorrow at 8:30 a.m.
Yes, Your Honor.
So I find probable cause, and I'll leave the standard bonds in place at this time on
Thank
the
you very
other
much. That's what I
charge.
was going to ask.
Okay,
Appreciate it, Your Honor.
all right, you're welcome.
Louis, I'll see you tomorrow morning. Have a good morning.
You too. On page 8, Tivante Williams.
Mr. Williams, come on up, sir.
First one on Friday.
All right, Mr. Williams, you're before the court this morning for an out-of-state felony hold. This is for the state of Ohio, and they've issued a no bond hold on this. So you will have to go before the extradition judge. Those courts are held on Tuesday and Thursday of every week. I don't know if you'll make tomorrow's docket, but I guess the soonest you'll be before the judge is on Tuesday, okay? All right, Mr. Plant? All right, folks, were you here for the previous case? Did you have a question? Okay. Ma'am, it doesn't matter what you say this morning. He has a no bond hold from another state. There's nothing that I can do about that this morning.
I understand that.
So if you have any argument to make, you may want to save it for Ohio, okay? All right? Okay. All right, on page 2, Jennifer Hill. Okay,
I believe she's been transferred to mental health to, where she is.
she has been, or are you asking for her to be?
Mr. Linder,
Does-
Jennifer Hill.
Has Ms.
Yeah.
Hill been transferred to?
Lerner Ren, maybe?
The email went out this morning. She's being referred.
Oh, it's a referral. All right, so, and does that mean when will she see Judge Lerner Wren? Do we know? Because it's
I mean,
saying now that she has a status,
If
but,
I had to guess, I would say that her JA probably will put it on for tomorrow, but I can check.
but the email has already gone out?
Oh, yeah, it already went out.
All right, so Ms. Hill, you're before the court today on a misdemeanor KPS. It's on a municipal ordinance violation, and you've been referred to Judge Lerner Ren's division, so I'm going to make sure I sign that order. That judge already knows that you're coming to her, and so you'll see her soon, okay?
See you tomorrow, ma'am. Thursday.
All right, on page 3, Leslie Vargas, and Madam Clerk, I need an order transferring Ms. Hill to Judge Lerner Ren. On Leslie Vargas?
Yes.
Hold on just a moment, ma'am. Yes, yes, count 10, yes. Okay. And 11 is 50. Okay, so it's just transposed. All right, so Ms. Vargas, you are before the court because you have a total of 13 misdemeanor capuses, all on municipal ordinance violations. And so, do we know when she would go to court? I don't have that information. So, based on the number of capuses, ma'am, I find probable cause. I am going to leave the standard bonds in place. And you will see your division judges on these matters, okay?
So she knows, because we spoke earlier to her.
Okay.
Her offer from the city is 15 days, so.
To
like, I-
resolve all of them?
Yes.
Are they all from the same city?
Yes, all Hollywood, but Ms. Vargas mentioned she had other cases pending, so it's better if she just went to division.
Okay, all right.
And
All
it's
right.
15 days, ma'am, so.
Okay, good luck, ma'am.
So I'm doing 15 days?
No, you're going to go before your division judge, okay? Because
Okay.
apparently there are 13 capuses here, and there's indication that there are other ones, okay?
Okay, when will I see that, Judge?
I don't
know?
have that
Soon, ma'am,
information, okay?
Okay,
All right?
thank you.
All right, on page 13, James Tanis.
Maine.
All right, Mr. Tanis, you have 3 misdemeanor capuses. These are from last year, October 29th, 2018, December 3rd of 2018. The charges are not having occupational license, operating without county auto. So it's all on the occupational license issue. So I find probable cause. And what does Mr. Tanis want to do today?
Judge, he has court tomorrow. I don't
All
have
right,
offers for
there's
him.
issues, okay. All right, so
have
Mr.
an offer.
Tanis, you'll be before your division judge tomorrow morning at 9 a.m. and your attorney will be there. All right, on page 14, Stefan Jackson. Yes. Where, can I see the paperwork again on Mr. Tanis? Oh, okay. All right. All right, Mr. Jackson, you are before the court on 4 municipal ordinance violations: petty theft, disorderly conduct, trespassing, and possession of a cannabis less than 20 grams. Those are all the charges that you're facing today. I find probable cause. And you have a standard bond of $25, which I am going to leave in place at this time.
Judge, he would qualify for a community court, I don't know.
Would he? Even with the
Well, I don't know.
cannabis charge?
No.
Well, you know what? They did say, they
Priors.
did say that there are state charges
Jackson.
that they'll accept, but does he have priors?
That's what I'm gonna check right now.
Okay.
Stephen Jackson, or Stephen Jackson.
PH,
P-H-A-N,
A-N.
PHAN.
yes.
Judge,
Yeah.
I bond out. Can I do the bond out?
Your bond's $25.
Yeah.
Oh, is that what, okay, well, then you have a $25 bond,
Yeah,
okay?
you can do that, sir.
All right, Rashawn
Don't miss
King
court.
on page 14.
Steve.
Oh, he didn't have priors? Yeah, it's all right, yeah.
All right, Mr. King, you are before the court on a municipal ordinance violation. The charge is petty theft. I find probable cause. What does Mr. King want to do?
Sir, would you like to resolve your case?
Yes.
What's the offer, Mr.
Adjudicate time served, Your Honor.
All right, so Mr. King, if you wish to resolve your case, the offer from the city is adjudication, time served. The case will be resolved today. There will be no formal information filed. There will be no further investigation of the matter. Do you wish to resolve the case today, knowing what your sentence will be?
Yes.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. King, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would prevent you from making a decision about this case?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served, and also there's an order not to return to that Family Dollar store in Fort Lauderdale on Broward Boulevard. Do you understand that, sir?
Yes.
All right.
Yes, sir.
All right, Bevel Simon on page 15.
Judge, I've been informed he bonded.
All right, Mr. Simon bonded. I find probable cause. And then Cedric Ellis, also on page
Mr. Ellis?
15.
Come on up. Please approach.
All right, Mr. Ellis, you are before the court on a misdemeanor capias on a municipal ordinance violation. Open uncovered beverage in public is the charge. What does Mr. Ellis wish to do today?
Judge, he wants to resolve his case, it's adjudicate time served.
All right, Mr. Ellis, the offer from the city to resolve your case is adjudication, time served. Do you wish to accept that, sir?
Yes, ma'am.
All right, sir, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Ellis, do you understand the offer that has been extended to you today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Ellis, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence, sir, is adjudication time served. Good luck.
Thank you, ma'am.
All right. All right, then, let's go to Nadia Nelson. All right, good morning. And Miss Nelson, you are before the court on, one charge of aggravated assault with a deadly weapon. It's domestic violence. I find probable cause. Does Miss Nelson have any priors?
Yes, Judge. I'm showing that Ms. Nelson is currently on probation right now for 2 separate DUI cases in front of Judge Carpenter-Toy. One moment. One, she was placed on a year's probation May 17th of this year. 1 DUI and a second case with an enhanced breath.
All right. So, are you here on this case?
Yes, I am.
All right, well, who do we have here?
Adrian Hepburn.
Okay, so you're the alleged victim in the case? And, is there something that you wish to say today? No, just answer that question.
Yes, there's
All right.
something I wish to say.
Okay, so you are the alleged victim in the case, and I cannot give you any advice except to let you know that everything you say on this record is being recorded and can be used against you at a later time. And so knowing that, do you still wish to say something? All right, so then I'll put you under oath. I'm gonna ask you to raise your right hand. Do you swear or affirm to tell the truth? Okay, sir, you can put your hand down. If you'll just step a little bit closer to the microphone so we can hear you. And then please state your name again for the record.
Adrian Hepburn.
All right, and then Mr. Hepburn, what is it that you wish to say?
We just had an argument that I don't know how it ended up with her being arrested. It was nothing like she's just a little bit frustrated. My wife is a PhD student. We moved back into her mom's house, and her mom passed away a few months ago, and she's just been a little bit frustrated. And we're trying to like figure out our life. I don't know why she ended up in jail for an argument.
All right, has there been prior violence in the home?
No,
Are you afraid of Miss Nelson?
no, I'm not afraid
And
of her.
do you want to have continue to have contact with Miss
Yes,
Nelson?
I do.
All right, okay, state, thank you.
Thanks.
Yes, Your Honor. I mean, this, according to the report, this is clearly more than an argument. At least one knife was involved. Mr. Hepburn, according to this, told law enforcement that she threatened him with a knife and that he was in fear for his safety during the incident.
Okay,
I would take issue with one thing that the officer says in the probable cause affidavit. The last paragraph, he says, due to the lack of consistency in the defendant's story and the consistency in the victim's story, the defendant was arrested. But there really is not an inconsistency in her story. She never changed her story. What she did, according to the officer, is change her mind about whether or not she wanted the police to be involved in the case anymore. But it's not as though she gave inconsistent statements about what had happened. She has been a resident of Florida all of her life. She has her master's degree in criminal justice from the University of Central Florida. She's been living in the same location with her husband since 2017. She's still a full-time student. And she is actually, I believe, the one who called the police.
Oh. And, Your Honor, I would note it would be a bit inconsistent if, in fact, she did call law enforcement, told the officer that he pulled a knife on her, but couldn't advise the manner in which he had the knife, then advised that for some reason she called the police, even though she said no threats were made, nor did he make any advances with the knife. There are inconsistencies.
all right, and based on those inconsistencies, I guess the officer had to make a decision.
I
So,
understand that.
how much bond are you able to afford? Whoever wants to answer.
talking about 10%, which is 100.
All right. Well, taking into consideration that there's been no priors, the testimony of the victim this morning, Mr. Hepburn, that he's not in fear, that there's been no prior incident of violence. I find probable cause. I am going to impose a $2,500 bond, and I will not impose the no contact. Okay? All right. Sabrina King.
Approaching Judge, you see our name?
All right, Ms. King is before the court on one charge of offering or agreeing to secure for lewd act. I find probable cause.
Judge, in speaking, Ms. King, she wishes to resolve this matter today.
All right, does the state have an offer?
One moment, Judge. Be a withhold court cost HIV test.
Okay.
Judge, she wishes to accept the state's offer.
All right, Ms. King, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And ma'am, do you understand the offer that has been extended to you?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Right. Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, ma'am, is a withhold adjudication, court cost. I'll give you 6 months to pay the court costs, and also you have to take an HIV test. You must report that you have taken the test. You don't have to submit the result of the test. Do you understand that?
Yes, ma'am.
All right. Paula Leon Ladino.
I've been advised she bonded, Judge.
All right, Ms. Ladino bonded, and I find probable cause. Jacqueline Naredu.
North Broward.
All right.
Oh, I'm sorry, Paul Ryan.
All right. Ms. Naredu, you're before the court this morning. Charge 1 is DUI, alcohol, or drugs. Number 2, driving while license suspended without knowledge. Number 3, no tag light. Number 4, failing to drive in a single lane. 2, 3, and 4 are traffic infractions and not for magistrate. I find probable cause. And does Ms. Naredu have any priors?
She informed me that she does not, Your Honor.
Okay.
And she has been living here for 19 years. She's been in the house cleaning business. She had one job with one firm from 2007 to 2019 this year. And she's been at her current job for the last 6 months. And she does not have money saved for a monetary bond, so we'd be asking the court to consider pretrial release.
And does the
I'm
state
not
wish to
showing
be
any
heard?
priors.
Okay. So then I'll ROR Ms. Naredu to pretrial supervision. And ma'am, what that means is you're not going to have to post a monetary bond, but the deputy will give you the information for the pretrial office. You must report by tomorrow morning. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
And also, you will be subjected to random alcohol and drug testing. Do you understand that?
Yes, ma'am.
All right? All right, so no alcohol or intoxicants and random testing.
Thank you very much.
All right, Sandra Kelly.
She's a medical reset, Your Honor.
Ms. Kelly is still a medical reset. Destiny Barnes.
Medical reset also.
All right, Ms. Barnes is also a medical reset.
Your Honor,
Yes?
Miss Kelly, could the court make a PC finding? I'm showing she was arrested almost a week ago.
Really?
Yeah, I'm showing she was arrested November 7th.
So she's been on medical reset all this time? Oh,
know-
I
I
see
know
2 times at least now.
Yeah, I know the note I have here, when she first came in, she was a medical reset.
All right, so as to Ms. Kelly, the charge is trespassing, and so I find probable cause. And, all right, I find probable cause in absentia. All right, Rashika Pereira.
She's approaching, Judge, you have one?
All right, Ms. Pereira is before the court on 1 charge of fraud, uttering a false instrument, and I find probable cause.
Judge, my understanding, Ms. Pereira has no prior contact with the criminal justice system. If the state can confirm that, I'm going to be asking the court to consider releasing a straight ROR. If not, she did give me the phone number of her child's father. I'm going to be asking him to post her monetary bond.
She had contact in Massachusetts about 9 years ago. It was a low-level misdemeanor offense, though, Judge.
All right, well, this, the allegation is that she attempted to cash a fraudulent check for the amount of $898, and further, that the checks were lost as a result of a burglary of a conveyance. And so I am going to leave the bond in place at $1,000.
Yes, Judge.
Joanne Marie Marsaro,
Medical Broward, I believe.
still a medical okay.
Your Honor, again, I would just ask, she was also arrested November 7th, if the court could make a PC determination on this case as well.
So as to Ms. Marsaro, I find probable cause. We'll have to bring her back to set a bond.
Sure.
Okay. Edwards Oliphant.
Please approach, Judge.
All right, Mr. Oliphant is before the court today on 2 out-of-state felony holds. These are both for the state of Georgia, and those are no bond holds. I find probable cause that Mr. Oliphant will have to appear before the extradition court, okay? And Marcus Renaud.
Mr. Ronaldo is approaching, Judge.
Mr. Renaud is before the court, 1 charge of possession of MDMA. 2 and 3 are felony capuses. Those are no bond holds and are not for magistrate. Number 4 is a misdemeanor capus. You have a $1,500 bond there. I find probable cause, and you will see your division judges tomorrow and the following day on the capuses, okay? I'll leave the standard bonds in place. Chaz Jackson.
North Broward.
All right, Mr. Jackson is before the court on 1 charge of aggravated assault with intent to commit felony. It's a domestic violence. Number 2 is criminal mischief. Number 3 is a civil writ with a purge amount of $300. And then number 4 is an out-of-county misdemeanor hold out of Dade County on a battery charge, and that has a $5,000 bond. That's also not for this court.
Honor, if I
Yes.
could be heard.
Yes.
I know the officer booked it as an aggravated assault. This really reads as more as a aggravated battery against a pregnant victim.
The defendant grabbed the victim by the throat, pushed her up against a wall, continued to choke the victim until separated by a family member. All right, and so I find probable cause as to charge one, aggravated battery, and we need to set a bond.
Brian, if you want to go first, that's fine.
Sure. Judge, I advise Mr. Jackson that the court really can't do anything about count 3 and count 4.
Okay?
But he is hoping that the court will set a reasonable bond on count 1. He has been a resident of Florida all of his life. He's been living at the same location for the last year. He will be able to find a place to stay without being in contact with the victim. He can live with his mom. Unfortunately, Mr. Jackson suffered a gunshot wound back in May and is still recuperating from that, is not able to really work at this point in time. So he doesn't have any money saved. And I think the last contact he had with the criminal justice system, from what he advises me, is DWLS last year. So I'd ask the court, I'm going to call his mom. He says his mom is rather elderly, does not have a lot of money to post bond for him. So I'd ask the court to keep that in mind.
Your Honor, actually, it would appear the last contact he had was charge number 4, the battery out of Dade County, and it causes great concern, and that's why I'm going to be asking for a $15,000 bond and a GPS monitor. According to CCIS, the listed victim in this case is the same alleged victim in that case. And on September 27th of last year, he was ordered to stay away from the victim in this case. There is nothing in CCIS.
September of when? Last year?
Yes. There is nothing to indicate at any time that that stay-away order was modified.
Apparently now she's pregnant and he's attending doctor's visits with her.
Every day.
Don't say anything, Mr. Jackson.
I'm sorry.
Yeah. He already had a $5,000 bond on that case just for failing to appear in court. Now there's allegations that he not only violated his judge's order to stay away from her, but now there's allegations of committing violence against this woman. I can also advise the court he has been to state prison in the past. Out of Broward, 2009, sale delivery of cocaine, grand theft auto, 1 year and 7 months state prison. 2017, improper exhibition of a weapon. 2013, he was arrested for 2 counts of battery that was dropped. Showing total 4 prior felony convictions, 11 prior misdemeanor convictions.
I can advise the court, based on my conversation with Mr. Jackson, that he and his mother are not going to be able to afford that kind of a monetary bond.
All right, well, this court can't ignore the fact that he has a pending battery charge in Dade County with the same alleged victim. That that there is a no contact order in place, and that despite, I don't know what's going on, there is a violation of that. And now he's before the court today on an aggravated battery with the same person. If you want to speak, Mr. Jackson, that's between you and your attorney.
Yeah, I would advise you not to say anything, Mr. Jackson.
Well, I'm saying we stayed together. We moved from Dade County to Fort Lauderdale.
Right, and so there is a no contact order in place, and that no contact order stays in place until it's lifted by a judge. If it has not been lifted by a judge, whether you're in Dade or Fort Lauderdale or wherever, it's a violation of a no contact order.
I went to court in Dade for that, and they dropped it.
Obviously not, since you have a capias for Dade. So, anyway, I am going to impose a $10,000 bond on charge number 1. The other standard bonds are going to remain in place, and I am ordering a no victim contact. And again, that means no phone calls, no text messages, no social media, no third-party contact. I hope you understand that, sir. All right,
She was.
Aurelio Gonzalez.
But it's a municipal ordinance, so I couldn't represent her. Steve Plant was representing her, but I guess they're gonna send her over.
Here, present, Judge O'Neill.
Mr. Gonzalez is also before the court on aggravated battery. Offender knew or should have known that the victim is pregnant. It's domestic. I find probable cause. Does Mr. Gonzalez have any priors?
Showing in 2017, he was arrested for domestic violence battery out of Hillsborough County. He went through a diversion program. There's nothing to indicate who the alleged victim was on that case. Based on his previous arrest for domestic violence battery, and the level of violence alleged in this case, and the victim's physical condition, I'd be requesting a $5,000 bond, no victim contact.
Okay.
Judge, and speaking Mr. Gonzalez, he's 38 years old. He works in demolition. My understanding is he's gonna try and contact his employer to help post his bond, but he doesn't really know if his employer will and how much his employer can help him post his monetary bond. So I'm gonna be requesting a phone order, and also as far as a monetary bond, Judge, I'm gonna be requesting a $2,500 bond on Mr. Gonzalez's behalf.
All right, I'm imposing the $5,000 bond and no victim contact until further order of the court. No phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Gonzalez?
Yes, Your Honor.
Okay. All right, Ian Parks.
I believe Conti, Judge.
Conti, Your Honor, he's in courtroom 6870.
Your Honor?
Yes,
He's
for arraignment.
He's in court for arraignment. This is really just, it's a bond surrender, and the only issue, it's even before the court, is because there was a change of charge. In full candor, I can tell you Judge Murphy originally set the bond at $1,000, so that is the bond he should have set on him at this point.
Is Mr. Parks represented by the Public Defender's Office?
1 moment, Judge. There is no notice of appearance.
All right. He's in court this morning. Do you think we can get him here this afternoon? If he has no attorney, All right, I'm gonna reset Mr. Parks for the PM docket and see if we can get him on, okay? James went out. Antonio Little,
For the record, Judge, Mr. Parks refused the services of the Public Defender's Office.
oh, he did?
Yes, when we went to interview him on October 6th, he refused and indicated that he has his own private attorney.
But we don't, but
And I'll try and find out.
is there
who that
anyone
might
who's
be.
filed a notice of
No, I
appearance?
looked in Odyssey. There's, let me make sure that no one filed anything with my office, but I don't think so.
Mr. Little, this discussion is not about you, it's about another matter, so just hold on a moment, okay?
Yes, ma'am.
There's no, I don't have any,
All right, so with that said, then, this is a change of charge to aggravated battery on a pregnant female, and he previously had a $1,000 bond?
yes, ma'am.
All right, so I'll leave that in place, okay? All right, and then Mr. Little, yes, no. Mr. Little is before the court on 3 traffic cases. These are now 5, 6, and 7. And those have on number 5, the judge did ROR you, Judge Hurley. on number 6 and 7, you have $1,000 bond on each of those offenses, but this was, November 5. Was, Mr. Little in custody at that time?
Yes.
All right, but, what else is holding him in custody?
A no bond on a felony VOP and $3,000 on 3 separate drug possession charges.
All right, so you have, $1,000 bonds on, the other matters, okay? All right, good luck, sir. All right, on page 22, Kirby Peterson.
Mr. Peterson is approaching, Judge.
All right, good morning, folks. All right, Mr. Peterson is before the court on one charge of aggravated battery causing bodily harm. And I find probable cause. And I'll hear from the parties. I'm assuming you're the parents?
Yes.
Okay, is there something you wanted to say in regards to setting the bond?
I'm a single mom. Kirby lives with me, and I have a job, but I don't make a whole lot of money. So if you can just, the bond so high so I can at least try to get him out, because he's a good child, and this is his first offense. It was a schoolhouse fight. I really don't know what happened because no one has talked to me about it yet. So I really don't even know what happened. It happened in school.
Okay. Well, just based on the allegations that I have, apparently it is alleged that somebody tripped him and made him fall, and that when he turned around, it just says assumed, there's not even any confirmation that, I'll tell you exactly what it says. The defendant was tripped by an unknown student at that time and fell. Defendant stood up and saw the victim and immediately assumed the victim made him fall. The defendant then picked up a board, which appeared to be from a ply box, and struck the victim in the back of his head. And the victim's mother desires prosecution, so that's the information that I have. All right? I'll hear from the state at this time.
Your Honor, just checking, it does not appear that there is any history. I'm going to request a $2,500 bond and no victim contact.
Mr. Romero?
Judge, as the court is well aware, there's usually more information that's omitted from the PC affidavit. My understanding, and speaking Mr. Peterson, it was more than a trip, it was a trip and a punch. But having said that, I did explain to Mr. Peterson that's going to be for a future court date to determine. But as the state said, he has no prior contact with the criminal justice system. He's 18 years old, been here his whole entire life. He's a senior at Whittam Rogers. He lives with his mom. My understanding, Judge, is his mother's going to be the only person that's going to be able to help post his monetary bond. As you heard from his mom directly, that her funds are limited. She doesn't have a lot. So I'm going to be requesting the court impose a $1,000 bond.
Why is he at Whittam Rogers?
He's not reading Rogers to make up his credits so he can graduate. He needs, I think, 7 credits to graduate.
So is he enrolled in a regular program and then doing Whittam Rogers in addition?
No, he's just doing Whittam Rogers. He's full-time at Whittam Rogers.
Okay. And is he working?
Not at this time. He's currently looking for a job.
He was working at McDonald's and went in the restroom and his stomach was hurting and they gave him
All right, so I am going to release Mr. Peterson on level 2 pretrial. And I'm assuming, Mom, that you did say that he lives with you, correct? So I am going to ROR him without the requirement of a monetary bond, but he will be on an anchor monitor and no victim contact. And so if he sees other students, he's gonna have to go in the opposite direction. You might have to let the school know that there is, well, not might, you will have to let the school know that there's a no contact order in place. All right? Okay. And no social media messaging, no social media messaging, no texting, no phone calls, and no third-party contact. That means he can't ask somebody else to be in contact with the alleged victim, and none of that. Do you understand that? All right. Mr. Peterson, most importantly, I know your mother is saying she understands. Do you understand?
Yes, ma'am.
Okay. All right, good luck, folks. All right, Terrence Mack.
He's approaching, don't you, sir, Mr. Matt?
Good morning, Judge.
Good morning, Mr. Mack. You are before the court this morning on one charge of disorderly intoxication. And number 2 is trespassing on occupied structure or conveyance, and I find probable cause.
Judge, and speaking Mr. Mack, he wishes to resolve this today.
Yes, it is. Sorry.
One moment, Judge. Your Honor, it appears there haven't been any issues with Mr. Mack since earlier this year, so I'll offer him adjudication time served, no return at this time. If he goes back to this location, though, and he gets arrested for it, the offer from the state will not be an adjudication time served.
All right, so Mr. Mack, in short, whatever you've been doing to stay out of being arrested for these types of charges, you need to go back to doing that. Do you understand that?
Yes, ma'am.
All right, you wish to accept the state's offer for time served?
Yes, ma'am.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Mr. Mack, do you understand the offer that has been extended to you to resolve your case today?
Yes, yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served. I'll give you 6 months to pay your court costs. Good luck, sir. All right, Michael Savio.
Mr. Savio, come on up, please. He's approaching, Judge, your name.
Mr. Savio is before the court on a petty theft charge, and I find probable cause.
Judge, and speaking Mr. Savio, he wishes to resolve this matter today.
All right, State, you have an offer for Mr. Savio? Is this from this morning?
Yeah, that was from earlier. It was perfection, but it still has to be signed.
I haven't done any perfections this morning.
Actually,
I have no idea. I haven't been in.
I haven't handled any perfection this morning, so.
If you don't mind me inquiring.
Sure.
When was the finding made? Or, here, I'll take a look at it.
Sure.
As far as Mr. Savio. Thank you. No, Your Honor, this is on the case from earlier this morning when I asked for a ruling to be deferred for 24 hours. It wasn't a perfection. It's just, I'll walk back. It's just,
Okay.
just what he said. Offer B, a withhold court cost, no return.
Judge, he understands the offer and he wishes to accept it.
All right, and Mr. Salvio, just so you understand, if you get a third petty theft, even if the amount is $1, it can be charged as a felony. Do you understand that?
Yes, Your Honor.
All indications are that this is the first one, so you need to keep that in mind.
Yes, Your Honor.
All right, so with that said, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, Your
Okay.
Honor, I do.
Okay, sir, you can put your hand down. And Mr. Savio, do you understand the offer that has been extended to you today?
Yes.
Is anyone forcing you to resolve your case? I didn't hear him. Is anyone forcing you?
No, Your Honor, no.
Are you under the influence of drugs or alcohol?
No.
And do you need any more time to speak with your attorney?
No, ma'am.
You understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter at this time, sir? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves a withhold adjudication and court cost, and also an order not to return to the Walmart on Atlantic Boulevard in Margate. Do you understand that?
Yes, Your Honor.
Okay. Zachary Giordano.
He's approaching Judge Germain. Come on up, sir.
All right, Mr. Giordano is before the court on a traffic capias, and this capias was issued October 10th of this year because you did not show up for a calendar call on a reckless driving charge. And so I find probable cause. At this time, I am going to leave the $500 bond in place, and you're scheduled to see your division judge tomorrow at 8:30 a.m.
And Judge, Mr. Giordano wanted to know if the state had a plea offer for him.
Based on the nature of the charge, I'm not going to take a plea this morning.
And just so he's aware, the documented offer involves probation, which we really can't do out of
Right.
here.
All right, Roman Riselli.
He's approaching, Judge.
And Mr. Riselli is on, before the court on a misdemeanor capias. This is on a possession of cannabis, 20 grams or less charge. You did not show up for your arraignment on August 21 of this year. That judge issued the capias with a $50 bond. All right, so I find probable cause.
He wishes to resolve this matter today, Judge.
Withhold court costs.
All right, so the offer is withholding court costs. Do you wish to accept that, Mr. Riselli?
Judge, he wishes to accept the state's offer.
All right, have you had enough time to speak with your attorney?
Yes.
And you understand the offer?
Yes.
All right, and you wish to accept it?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness? And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Riselli? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves a withhold adjudication and court costs. Good luck, sir. Michael O'Brien.
Mr. O'Brien, come on up, please. He's approaching, Judge.
Mr. O'Brien, you are before the court, charge 1, DUI, alcohol or drugs. Number 2, DUI with damage to property or person of another. Number 3 is the same, DUI with damage to property or person of another. And number 4 is failure to use due care. That's not for magistrate, it's a traffic infraction. I find probable cause.
Judge, and speaking of Mr. O'Brien, he's not gonna be able to afford to post a monetary bond. We're gonna be requesting the court consider releasing him on pretrial release. Now, my understanding, he's been here his whole entire life, he's 31 years old, he's working for a flooring company. He's been there employed for 9 months. He lives in Davie with his mother, she works at Fresh Market, and from what he advised me, he doesn't believe that she can afford to post a monetary bond. Now, he does have prior contact with the criminal justice system. My understanding is, I believe they were old cases in which he self-surrendered, I believe in 2017, and took care of those cases. But right now, he's asking for the court to consider releasing them under supervision.
All right, State.
One moment, Judge. I don't have a problem with pretrial random testing.
All right, so I'll release Mr. O'Brien to pretrial supervision. And Mr. O'Brien, you need to make sure that you show up for pretrial within 24 hours of your release.
Yes, ma'am.
Sir, if you don't go, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
And also, there'll be random alcohol and drug testing as a condition of your pretrial release.
That's fine.
All right? Eric Russell.
All right, Your Honor, he's in court.
All right, Judge.
All right, Mr. Russell's in court.
She's gonna be missing count 1.
Yes.
Okay.
For sure. Because for some reason they didn't book the change of charge.
All right, we'll have to reset Mr. Russell. Bernard Osias,
All right, Your Honor.
he's in court.
Reset for-
We'll reset. All right, Mr. Osias is before the court. This is for an add charge of burglary for dwelling or structure or conveyance. And it says number, is it, what, it's number 2.
It's-
So
yes.
What's number 1?
Your Honor, he's being held no bond on a robbery firearm. It's part of the same case. Court had previously found proof evident or presumption great. I printed a supplemental report for Your Honor and Mr. Reedy, which covers the same details. There's more specific detail that was in the original report, which notes an allegation that when he possessed the firearm, he reached part of his body into the vehicle when he stole the victim's purse, and that is the basis for the allegation, the charge of the armed burglary. In light of the no bond hold on count 1, the state would be seeking a finding of proof evident or presumption great for first appearance purposes.
Okay.
Well, I do have some issues with the identification process in this case, but in light of the fact that Mr. Ocasius is already being held no bond, we would defer any argument regarding proof evident presumption great until such time as he can appear before his division judge.
All right, it appears that arraignment is scheduled for November 18th on this matter. And at this time, as to this charge, I will make also a preliminary finding of proof evident presumption great. And this is without prejudice for Mr. Osias to have a bond hearing based on State v. Author. And so until such time, he will be held no bond on this charge as well. Okay?
Excuse me, Your Honor.
Yes, yes, sir.
Holly Rivers on page 28 toward the end. He's in court also. That's my last one.
Who is that? Who is that?
Rivers, Stanley?
The last name is Stanley? Oh, Rivers.
No, last name is
Rivers.
Yes.
The last case.
So Mr. Rivers is in court as well?
This one. Yes.
So, the only thing, Your Honor?
Yes.
Just want to check.
This is a change of charge.
Yeah, I just want to make sure it's not one of those situations where, okay, yeah, I guess we'll see him tomorrow.
All right, so thank you, Deputy, and we'll reset Mr. Rivers for tomorrow.
Actually, Your Honor, if I
Yes.
could just have one moment, because I see on the docket, it says change of plea for this.
Change of plea?
Change of plea. So I just want to confirm if it was in fact set for a change of plea and he's represented by the public defender, Mr. Reedy might want to waive his appearance. Yes, Your Honor, he is represented by the public defender's office, and I'm showing he's been scheduled for change of plea yesterday and today.
Oh. All right, well, we'll leave the, Mr. Aridi, do you have any objections? All right, I'll leave the bond in place on the charge of possession of utilone. This is on Stanley Rivers, so no need to reset. All right, thank you, Deputy. Larry Covington?
He's here present, Judge May.
All right, Mr. Covington is before the court on an ad charge. This is now charge number 17. This is for burglary, unoccupied conveyance, unarmed. All right, I find probable cause.
Your Honor, he has no bond holds, and on his only other burglary conveyance charge, bond was set, I don't know if it was over the weekend or yesterday, set at $5,000. I'd be requesting that the same bond be set on this burglary conveyance.
Nothing to add.
All right, so we'll set the bond at $5,000. Javar Campbell.
Mr. Campbell?
All right, so Mr. Campbell was here yesterday, so I assume that this is just for the ad charge of the immigration hold?
I believe so, Judge.
All right, so Mr. Campbell, there is now an ad charge. Number 2, it's an immigration hold that has been placed by the Department of Homeland Security, and that is a no bond hold, so you will have to appear before an immigration judge on this matter, okay? Roland Allen.
He's present, Judge.
All right, so Mr. Allen, there are 2 reasons why you're here today. Number 1 is there's a charge of driving while license suspended, habitual. Number 2 is a bond surrender on a felony charge.
So DWS habitual offender also.
So that's the same, and that's a $750 bond. It's not for magistrate, so I find probable cause, and the bonds will remain in place. It looks like there's some motion or some calendar call tomorrow at 1:30 p.m. All right, Mont Trevine Johnson.
Come on up, sir. He's a present, Judge.
All right, Mr. Jackson is before the court. Charge 1 is defrauding a financial institution. Number 2 is grand theft. Number 3 is fraud, using or possessing the ID of another person without consent. And I find probable cause for these charges. I hear from the parties.
Judge, nothing to add from the defense at this time.
All right, so I'll leave the bonds in place. All right, so he has 3,500, 1,000, and 1,000. Richard Priester.
Mr. Priester, come on up, please.
All right, Mr. Priester is before the court on a petty theft charge, and I find probable cause.
Judge, nothing to add from the defense. I'm going to be contacting his wife after I get out of here.
All right, so he has a $750 bond. Wesley Michaud.
He's the person, Judge, here, man.
Mr. Michaud is before the court on 3 burglary, 3 burglary and occupied structure unarmed, and 4, 5, and 6 are petty theft charges, and number 7 is driving while license suspended, and I find probable cause for these charges. Any priors on Mr. Michaud?
Checking that right now, Judge. Battery last year in Palm Beach. Possession of marijuana, Palm Beach, 2015. Filing 08 out of Palm Beach. This year out of Osceola County. I haven't seen this before, but fraud. One moment, Judge. It's basically fancy language to say that he was trying to get a free ride on a railroad train with a trespass. That's pretty much it, Judge.
Mr. Romero?
Judge, Mr. Mashad advised me he's not going to be able to afford to post any sort of monetary bond. When I told him as far what he was here for, he was surprised that the counts 1 through 6 he was only told in reference to the driving offense. He's been residing in Florida for 17 years. He's 32 years old. Right now, he's looking for work. He was previously working as a cook, making about $13.50 an hour. He lives in Lantana with his cousin. He's been residing there for about 5 years now. But right now, from what he advised me, no one's going to be able to afford to post his monetary bond, so that's why he's asking to be released on supervision, pretrial release, Judge.
He lives in Lantana.
Lantana.
All right, as to charges 1 through 6, the probable cause affidavit says that between Saturday, November 2nd and Sunday, November 3rd, 3 separate incidents occurred in which empty beer kegs were stolen, affecting 101 Ocean Restaurant and Aruba's Beach Cafe. And both through video surveillance, they captured the suspect, identified as Wesley Mashad, steal 4 empty beer kegs, 3 1/6 barrel and 1/2 a barrel, valued at $35 each. He entered a fenced-in exterior storage area that is not accessible to the public, only accessible via a rear alleyway to steal the items. That's the allegations for charges 1 through 6. Okay? It looks like, based on what your representation is, that he lives out of the area. So at this time, as to charges 1, 2, 3, I am going to impose a $2,500 bond, and then the other standard bonds will remain in place. Okay? Roberto Paz Trochez.
Mr. Paz, Trochez?
Mr. Trochez is before the court. Charge 1 is aggravated battery causing bodily harm. Number 2 is touch or strike battery, and number 3 is operating without a valid license. All right, I find probable cause. This incident arise out of road rage allegations. Allegations that he threw a hot cup of McDonald's coffee through the window of somebody who was trying to cut him off. All right. Does he have any priors?
I don't see any, Your Honor, based on the allegations and the fact that, according to the report, the victim suffered burns to her chest as a result of getting hit with the hot coffee. I'm requesting a $5,000 bond and no victim contact.
Judge. Considering the circumstances, at this time, that's reasonable, Judge.
All right, so I'll impose a $5,000 bond, no victim contact, and sir, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, I understand.
Okay. All right, Taekwon Cheatham.
Please approach it, Judge.
Mr. Cheatham is before the court, one charge of grand theft auto. Number 2 is fleeing, attempting to elude law enforcement. And I find probable cause.
Judge, nothing to add at this time. I'm going to be contacting Mr. Cheatham's mother to post a monetary bond.
All right, he has a $1,000 bond on each charge. John Nanali.
Mr. Nanali, come on up, please.
All right, Mr. Nanali is before the court. Charge 1 is felony petty theft. And number 2 is trespassing, occupied structure or conveyance. Number 3 is also a felony petty theft. And I find probable cause.
Judge, I'm going to be asking for the court to consider releasing Mr. Nanali under supervision of pretrial. He's 60 years old, been here his whole entire life. He's in the process of applying for disability. He lives in Miami with his mother. His mother is on Social Security. She's elderly, and Mr. Nanali helps take care of her. Now, he does have prior contact with the criminal justice system. My understanding from what he told me was in 2018. So on these non-violent offenses, I'm asking the court to consider releasing him under pretrial release.
The problem is that, and I guess Mr. Nunnally didn't share this with Mr. Romero, he was arrested 2 weeks ago for trespassing at Sawgrass Mills, where at least one of these thefts allegedly occurred. Prior to that, he was arrested April 24th of this year on a violation of probation on 2 separate felony thefts. He was sentenced to 270 days in county jail and was released August 20th of this year.
All right, so when I look at this booking report, Mr. Nanali has 27 AKAs with varying date of birth. And the allegations, this is shoplifting from guests at the Sawgrass Mills Circle. It said that he was taking the items off the mannequins. A total amount of $481.96. And then there is another incident at the Home Depot by Sawgrass. And there he was taking drills, a total value of $452.70. All right? And so based on these allegations, I am going to order a no return to the Sawgrass Mills Mall. And as to charge number 2, I am going to impose a $500 bond. All right. And then the other standard bond is also remain in place. Jeremiah Schmidt.
Mr. Schmidt, come on up.
So Mr. Schmidt is before the court today. Charge 1 is driving while license suspended habitual. And then 2, 3, and 4 are felony violations of probation. And those are for Judge Bailey. And those are no bond holds for Judge Bailey. And you'll see Judge Bailey tomorrow at 8:30 a.m. I find probable cause, and the standard bond on 1 will remain in place. Dwayne Montgomery.
He's approaching Judge, young man.
Mr. Montgomery is before the court. Charge one is possession of burglary tools with intent to use. Number two is burglary, unoccupied dwelling unarmed. And number three is criminal mischief. I find probable cause for these charges. Does anyone wish to be heard?
Sure, Honor. One moment. Honor, in 2010, Mr. Montgomery was convicted of 2 separate burglary dwellings, a third burglary dwelling in 2011, and a burglary structure in 2010. All the burglary dwellings also had additional charges of grand theft. On the burglary dwellings, he violated probation. He was sentenced to 78 months in state prison. On those 3 cases, the burglary structure, he was sentenced to 60 months in state prison. He had a trespass from last year that he just pled out about 2.5 weeks ago. Your Honor, I'm going to be seeking a $10,000 bond on count 2. No victim contact, no return.
What was it that he pled out 2 weeks ago?
Trespass.
Okay, Mr. Romero?
Judge, unfortunately, there's no way he's gonna be able to afford $10,000. He's right now working in construction. He's making about $15 an hour. He lives in Deerfield Beach with his mother. His mother's a cook. That's who he's gonna be reaching out to help post his monetary bond. He believes even using the services of bondsman, probably at most she'll be able to come up with a $3,500 bond. So that's why we were gonna be requesting $3,500 on count 2 on Mr. Montgomery's behalf.
Your Honor, I imagine that there's been some additional contact because I received word from a bondsman that one of his friends reached out to a bondsman about posting his bond however it's, depending on what it's set at.
Going to impose a $5,000 bond on number 2, and then the other standard bonds will remain in place and no return to this location. Damian Thompson.
Mr. Thompson, come on up, please.
Mr. Thompson is before the court on 1 charge of grand theft auto, and number 2 is operating without a valid driver's license, and I find probable cause.
Judge, Mr. Thompson advised he's not gonna be able to afford to post a monetary bond. My understanding, he's just got a job. He was supposed to start today at a place called Ghost Bar as a dishwasher. He's 26 years old, been here his whole life. He lives with his sister in Miami. My understanding, she's not working. She goes to school full-time. Nobody's going to be able to help post his monetary bond. Now, from what he tells me, he has prior contact with the criminal justice system. So based on that prior contact, we're requesting the court releasing him under level 2 pretrial release.
Prior contact that's being referred to was 2013 out of Gilchrist County, aggravated battery with a deadly weapon, intimidating a witness, and false imprisonment. He was sentenced to 5-year state prison. Grand theft out of Broward from 2012, also sentenced to 5-year state prison. His most recent release, Your Honor, it would appear that he was released early, and it would appear that he had a violation of his supervised release because he was arrested. He got out November 1st, 2016. He was then arrested December 21st, 2016, and was just released August 1st of this year.
All right, Mr. Thompson has a $1,000 bond. We will leave that in place at this time. And at this time, the court's gonna take a brief recess. All right, let's go to William Swackard.
Striker, if we can put him on brief recall, Judge, he's in the restroom.
Okay. Omar Scott.
Mr. Scott, come on up, please.
Hi, Dion.
I'm on Mr. Scott. Mr. Scott, you're before the court this morning for one charge of possession of a weapon or ammo by a convicted Florida felon. And I find probable cause.
Judge, we're going to be asking the court to consider releasing Mr. Scott on pretrial release. He's 42. He's been here his whole life. At this time, he's not working. He lives with his girlfriend in Hallandale. They're struggling right now financially. So that is why we're asking for the court to consider releasing him under supervision of pretrial.
Okay.
State will be requesting a $2,500 bond.
All right. $2,500 bond. Okay. Renal Samuels.
And Judge, whenever the court's ready, Mr. Swackard is back.
All right. So Mr.
Hey, Mr.
Samuels.
Good morning, Your Honor.
Mr. Samuels, good morning. Sir, you're before the court on a violation of parole matter, and this is a no bond hold for Department of Corrections, and you will have to appear before the parole board, okay?
Can I ask a question, Your Honor? Because if they don't come on time, they have to release me come next Tuesday on the 19th.
What? Next Tuesday?
Your Honor, I really don't know. It's really between him and the parole board.
All right.
No, but I'm saying, but that'll be the end of my sentence. They can't keep me past the 19th.
Sir, I don't know that that's true, because
Yeah, it is true. That'll be my whole entire sentence.
Okay.
November the 19th
All
to
right.
end my sentence.
All right, sir, you'll have to appear before the parole board, okay?
But I'm just
All
asking they
right,
keep
Samuel Randall. Samuel Randall.
Mr. Randall, come on up, please.
Mr. Randall is before the court on one charge of retail theft, coordinating with others, and I find probable cause.
Judge, he can't afford any sort of monetary bond. He's homeless. Right now he's looking for work. He's been here his whole life. But we're asking for the court to consider releasing him under supervision.
Does Mr. Randall have priors?
He's released from state prison March 1st of this year from trafficking stolen property, grand theft, false ownership info to a pawnbroker, sentenced to 1 year and a day state prison. One moment, Judge.
It looks like Mr. Randall, based on these allegations, is working in conjunction with his sister to affect this incident, and so I'm gonna leave the bond at $1,000, okay? Renee Gabriel.
Mr. Gabriel, come on up, please.
Mr. Gabriel is before the court on one charge of grand theft of a firearm, number 2, carrying a concealed firearm, number 3, selling cannabis within 1,000 feet of a place of worship or business, and number 4, resisting officer without violence. I find probable cause for these charges.
Judge, Mr. Gabriel advised me we can't afford to post the monetary bond as it stands. Specifically, as to count 3, we're going to be asking for a bond reduction from 5,000 to 1,000. He's been here residing in South Florida for 10 years. He's 25 years old. He works for a pressure cleaning company. He makes about $300 a week. He lives in North Lauderdale with his mother. And his mother works at a local Marshall's. So he believes if the total bond were around $3,100, that's something he can afford. So that is why we're asking for the bond reduction, count 3 alone.
Does Mr. Gabriel have any priors?
He does delivery of cannabis 2016, possession of cannabis with intent to sell 2013. I don't have an objection to a $1,000 bond on 3, Your Honor.
All right, $1,000 bond on charge number 3. So you have a total of $3,100 in bonds. Okay. William Swackard.
Mr. Swaggart, come on up, please.
All right, Mr. Swackard is before the court on one charge of passing, forged, altered bill or promissory note. Number 2 is a petty theft. Number 3 is a municipal ordinance violation for an open container charge. I find probable cause for these charges.
Judge, Mr. Swacker's going to be requesting pretrial release. He's homeless. He gets disability. He gets approximately $600 per month. He's 64 years old, been here his whole entire life. From what he advised me, no one's going to be able to afford to post his monetary bond, so that's why he's requesting pretrial release on violent offenses.
One moment, Judge. Theft at a date 2016. Is his most recent. I do see he is been to federal prison. This is in the mid-'80s. Possession of counterfeit currency, counterfeiting in the mid-'80s. He has been to state prison in Florida for burglary of an occupied dwelling, grand theft out of Broward, sentenced to 5 years, 8 months state prison. And I'm showing history out of Georgia for theft, violating parole. So noting he has used aliases in the past.
All right, Mr. Swackard, the standard bonds will remain in place at this time. Edward Harding. Mr. Harding is before the court on one charge of grand theft. Number 2 is resisting officer without violence, and I find probable cause.
Nothing to add from the defense, Judge.
All right, Mr. Harding has a total bond of $1,000. Reginald Payton.
Mr. Payton, come on up, please.
Mr. Payton is before the court on one charge of possession of cocaine. Number 2 is possession of drug paraphernalia. Number 3, resisting officer without violence. And I find probable cause.
Judge, we're going to be requesting the court consider releasing him on pretrial release. My understanding, Judge, he's living here in Hollywood with his brother. He's been there for about 5 months now. He's 37 years old, been living in South Florida now for 1 year. He says no one can pay his bond, so that's why he's asking for pretrial release.
Do you have any,
Checking that right now. He was picked up 2018 in California for failure to appear. 2018, transporter selling narcotics, controlled substances. 2018, use of controlled substance. Okay, hold on a second.
In reference to one of the priors, I believe Mr. Lender mentioned out of California, Mr. Payton was explaining to me it was a not me kind of case in which he was let go. But that's what he was disputing as far as prior in California, which Mr. Lender referred to.
But they charged me and then just let me go, so it shows up on my record like I was, you know what I mean?
2000, out of Leon County, 2016 theft.
all right, based on these allegations, he has a $1,000 bond, which I am going to leave in place at this time. All right, Miguel Telez Paz.
He's approaching, Judge.
All right, Mr. Telez Paz is before the court. Charge 1 is possession of cocaine. Number 2 is possession of drug paraphernalia. Number 3 is a violation of community control on a felony matter. Number 4, violation of community control on a felony matter. Those last 2 are no bond holds for your division judge, Judge Siegel, and you have a court date tomorrow with Judge Siegel. I find probable cause, and you have a $1,000 bond on charge number 1. Okay? All right, Sean Stephen Fletcher.
He's approaching, Judge.
All right, Mr. Fletcher is before the court this morning. Charge 1 is unlicensed money services, more than 20,000 but less than 100,000. Number 2 is fraud, money laundering, transfer, 20,000, more than 20,000, less than 100,000. Number 3, obtaining property over $20,000 by fraud. Number 4, fraud. Over $300, less than $20,000. Number 3 is obtaining property by fraud. Number 4, I said that, number 4 is fraud, structuring more than 20,000, less than 100,000. And then number 5 is an immigration hold. That is a no bond hold, and you will have to appear before an immigration judge based on the detainer placed on you by Department of Homeland Security. I find probable cause for these charges, and I'll hear from the parties at this time.
Your Honor, on counts 1, 2, and 4, I'm going to be asking for bond increases to 10,000 on each of them.
On which counts?
1, 2, and 4, to match count 3.
Okay,
Your Honor, I think that's more in line with the total monetary value of the property he was traveling with. I'm concerned because clearly he has no ties to the community. I have a concern just based the fraudulent nature of these allegations to begin with, the strength of the evidence against him, and one moment, Your Honor. And just also the information given by his co-defendant about his activities involving potential fraud of elderly victims.
okay. Mr. Romero?
Judge, at this time, I understand Mr. Fletcher is visiting from Jamaica. He works in construction. But having said that, my understanding, he does have family that lives here in South Florida. My understanding, he has a brother who's a registered nurse, I believe.
Well, brothers.
Brothers?
Yeah,
Okay.
more than one.
He has more than one brothers here that live in Broward County. So, Judge, at this time, I'm going to be asking for the court to consider leave the standard bonds placed 2, 4, and 1, and maybe consider bond reduction on count 3 from $10,000 to $5,000.
All right, so these allegations are that the defendant was traveling with $19,613 in U.S. currency, cash, and then $27,000 in cashier's check, a total of $46,613. Further allegations are that he's involved in a scheme calling elderly persons, advising them that they have won millions of dollars, and giving them specific instructions to where and who to send money in order for them to claim their winnings. I find these allegations to be alarming. And also take into consideration that Mr. Fletcher he is not from the state. I am going to impose a bond on 1 and 2 to $20,000. And number 3's got a $10,000 bond. And number 4, he has a $10,000 bond. And I don't know if that other person mentioned in the probable cause affidavit was also arrested, because there's another
Yeah, I
person
don't.
that
the
was also
co-arrestee-
a co,
I'm not. I mean, clearly they spoke to him. I don't know what ended up happening.
all right,
obviously.
okay. All right, Kevin Garajal, is he still on medical loan?
Check.
Garajau, still on medical loan? Okay.
Would the court be inclined to make a probable cause determination?
Is this
Obviously,
a several? We have a few, this is, I think, the third medical reset on Mr. Garajo, and so at this time, I will find probable cause. He has to be reset for a bond. Okay? Daniel Brown. Conte. Mr. Brown, is this Mr. Brown?
Yes.
Mr. Brown is before the court on a change of charge. KPS. Charge number 1 is now a burglar for dwelling or structure causing damage over $1,000. How much bond was initially, did he have?
it was originally set at 5,000. Your Honor, I'm just asking to be placed back on. He's got no bond holds.
All right, so find probable cause and we'll leave the $5,000 bond in place at this time. Okay? And then Estin Phils Magre,
He's in court being arraigned by Judge Kohler this morning.
He's in court. Do we need to reset him? Is it,
I would
oh, it's not
ask.
an immigration, okay.
Yeah, it was actually upfiled. So.
All right, so we'll reset Mr. Fitzmaugray for tomorrow, okay? All right, thank you, everyone. And- Yes, ma'am? Yes, ma'am. Whatever the previous conditions were, yes, and we'll add that, okay? All right, thank you, everyone.